Chris Day, over to you. Oh, he's got a timer as well. Brilliant, that's good.
I heard about it. Hello, my name is Dr. Chris Day. So I'm an NHS whistleblower. My whistleblowing case has been going on for 10 years, the litigation. It's about to go into its 11th year. And I want to put, in 5 minutes, I want to pull out a few things from my 10-year jungle of whistleblowing litigation to support this idea that the whistleblowing legislation in this country is failing and urgently needs to be changed. So I was an ICU doctor, so my whistleblowing case was all about an ICU in South East London in a reorganised trust. It was about serious staffing issues at night and about skill mix at night. And I say the failure to take note of those issues resulted in several avoidable deaths. My case is them essentially causing me detriment, trying to silence me and trying to confuse the issues. So that's what I would call the whistleblowing detriment case. And you'll hear this idea of whistleblowing detriment. But it's basically taking the doctor down, smearing them and covering everything up. And of course that's detrimental. But I think the issue here is not just detrimental to me, it's detrimental, well, at the very least, anyone in South East London that wants intensive care, which is potentially everybody. So it's very inclusive, these issues and how important they are. So let's consider the 10-year jungle of litigation that if anything is just hotting up. It's certainly not anywhere near finishing. So the first 4 years was spent undermining my employment worker status to effectively break whistleblowing law so my case could never be heard by a court. Now, as I mentioned, it's a very inclusive thing, this. So this was done not only to me, but to every doctor below consultant grade in the country, effectively, as the case progressed into the appeal courts, undermining their employment status. So the taxpayer funded, effectively, my employment status and that of 54,000 doctors being undermined just to stop my case being heard, and by default, every other whistleblowing case that might have been brought by a junior doctor. Now, sorting that out fell on my shoulders, not the government. The government didn't do anything. So I privately funded litigation over 4 years to defeat these ridiculous arguments in the Court of Appeal. And luckily, 5,000 crowdfunders joined me in that. But had they not, in a little employment tribunal in South East London, the nation's doctors would have lost whistleblowing protection, and nobody in government would have lifted a finger to do anything about that. And that's quite and I'm just warming up with what they tried to do to stop this thing from being heard. So we went along to the Court of Appeal over 4 years and defeated this argument. And the case finally got heard in 2018. Or did it? During my evidence, my legal team were threatened for costs. Ordinary costs against me and my family, and also wasted costs against them. And that is a liability felt by a small law firm and potentially a barrister. So those threats were not done in advance properly by letter. They were done on the cuff when I was under oath, so couldn't have frank discussions with my lawyers. And I think anyone who knows the story thinks it caused a mess. I think that's a very diplomatic way of me putting it. But it resulted in a settlement agreement and none of the cases being heard. And that's after 5 years of litigation, nearly $500,000 of public money, with a similar amount from my crowdfunders. And it ended in a settlement agreement and all the issues being buried. Or did it? In some ways, the world of employment law and whistleblowing law succeeded in crushing me, covering the issues up, and stopping the case being heard. Now, no offence, Lawrence.
No.
The employment lawyers amongst you are probably thinking, what's the problem? We did our job. We crushed the whistleblower, we stopped the case being heard, and we got rid of all the bad news. And it was a bargain. It was £500,000. And we know there might be some truth in that, but there's not much, is there? We don't want that to happen. And the reason it did happen is because we use and rely on the Public Interest Disclosure Act in this country. But the story, just, I don't want to get too depressing. That wasn't the end of it, because the NHS wanted to parade their crushing of the whistleblower with some public statements saying that they didn't threaten me for costs, because everyone was wondering why I would suddenly throw in the towel. And that waived a special privilege, which meant that I could speak freely about what led me to settle. And now that was not the plan. And the NHS managers involved need to go on a course about without prejudice privilege. Yeah. And so it came back to court in 2022. And I think this is even more simple. It was, I say the NHS lied to the press and MPs, denying cost threats and saying my case wasn't about an intensive care unit, which is ridiculous, but they said it. And they lied about certain investigations. Now, that is a very winnable, simple thing to bring to an employment tribunal that you would hope that even they could cope with. And then during that hearing, and I kid you not, and this is all reported in the press, we put so much pressure on the NHS organisation by bringing to court Jeremy Hunt as one of my supportive witnesses, a former Health Minister, Sir Norman Lamb, and two consultant anaesthetists, explaining with me in no uncertain terms how the press and Parliament, a load of local MPs, were misled when they were told that cost threats were not used as leverage to settle my case, and that the case was not about ICU. And their response during the hearing, one of the directors, was to destroy 90,000 emails of undisclosed material, admit to it in a statement, and then, without medical evidence, suggest mental health would be a credible reason not to attend for cross-examination. And I don't know what's more surprising, all I've just said then, or the fact the judge brought it. And the NHS won that case, which is astonishing. And that is basically where we are now. We're yet more public money being spent on litigation, this time an appeal, to say something basic. And I kid you not, the appeal is as simple as you can't destroy 90,000 emails during a hearing and expect the judgment to be credible if the judge ignores it. It couldn't be more simple. And I'll bring this into land.
Yeah, I've let you go over,
Yeah.
but I wanted to hear how it
But this is the landing point here is where what Georgina says. We cannot tolerate as a nation this dysfunctional Public Interest Disclosure Act, because what I've just described to you, I'm sure is unique in a lot of ways, but it's going on all over the country in various forms and has to stop. And we need to put polite pressure on our MPs to change this law and to see the urgency of doing so, which Dawn Butler is someone to be applauded because she's arranged this meeting, so I'm not having a go at you.